In this video, I'm going to discuss the second type of, I guess what you could call non-contract enforcement that is available, although very rarely, in situations where a valid contract was not entered into for some reason. Our first video talked about promissory estoppel, which is a situation generally that applies in cases where you may have had an agreement or you had at least a one-sided promise, but you did not have consideration. The consideration was not what we would call legally sufficient. And because of that failure of consideration, we can't say that a valid contract was formed, but promissory estoppel provides a very narrow route for enforcing certain types of promises nevertheless. This example here, the topic we'll be looking at today is called quasi-contract. In contrast to promissory estoppel, in these cases, this is generally a rule that applies where you don't even have an agreement. So we can't say that we have mutual assent, but for reasons that we'll get into in a moment, a court may nevertheless decide to enforce some sort of obligation to pay for a good or a service that's been provided at some point. So basically what we're looking at in these cases, oh, and again, this is another equitable doctrine. So this is another kind of a rule or sort of a principle of law that was developed in reaction to the perception of the courts in equity that the kind of early common law courts were just sort of too rigid, we're too narrowly focused on, we're going to look at the elements of a valid contract and nothing else. If you cannot meet those elements, sorry plaintiff, you're not going to be able to recover no matter what the situation is. But here again, just like we saw with promissory estoppel, these are cases where the courts in equity decided that they did want to step in, that they did feel that some remedy was appropriate, and so they kind of fashioned this concept to handle situations where there's just some sort of extraordinary unfairness with not enforcing some type of an obligation to pay. Again, just like promissory estoppel, these are very narrow doctrines. Of course, now we've already talked about our in every state except Delaware, courts in law and equity are now combined. So your general state level trial courts are going to be able to award both types of remedies. So you'd be going to the same place, whether you were filing based on a breach of contract lawsuit or whether you were having to kind of fall back and rely on promissory estoppel or quasi-contract. But, just like we said in the last video, do keep in mind you don't, it's certainly not ideal to be in a situation as a plaintiff where you're relying on one of these doctrines because they are very narrowly applied because they're exceptions to basically every other principle in contract law. So quasi-contract, the kind of key here, the main sort of the crux of what quasi-contract is all about, this is all about preventing unjust enrichment. And so unjust enrichment is kind of a term that goes way, way, way back early in the common law. You see it come up quite a bit in contract law, but also in other areas of the law too. It's just kind of a legal, kind of a long-standing legal principle that we don't like unjust enrichment, right? It doesn't seem like a policy that we'd want to promote to allow someone to, become enriched, right, to benefit in a way that is unfair, right? And a lot of times that means you're benefiting kind of at somebody else's expense in a way that really just seems right unjust or unfair. So that in these cases is what plaintiffs relying on this doctrine are trying to prove if they go into court, right? That it may be a situation where they're not even claiming that a contract was created. It may be a situation where their initial, right, their main claim in a complaint is a breach of contract case. But just like we talked about in, a little review of procedure here, we talked about how you can do what's called pleading in the alternative. So what a plaintiff may do is say, look, I think we created a valid contract here. I think we had an agreement. However, even if the court finds that that is not the case, At a minimum, I should be able to recover based on this principle of quasi-contract. So it could be a standalone claim, or it could be kind of a claim in the alternative. But basically, what the plaintiff is trying to establish is that the defendant will be unjustly enriched, kind of at the plaintiff's expense, if some enforcement is not forthcoming from the court. In these cases, because you don't actually have an agreement, right? That what that means is generally, these are usually service-based issues. I'm not super familiar with quasi-contract cases where I think it's less common to see like a good that's been provided. So a lot of these revolve around a service being provided. But essentially, what is going on here is that the plaintiff is saying, look, I provided some sort of a service to the defendant. No, we may not have had an agreement, or we may not have had any sort of mutual assent, but if I'm not compensated for that, it's going to benefit the defendant immensely, and that's not right. That's not fair, right? It's not fair to me. The defendant should be required to pay. But because there is no agreement, what that tells us is we don't have a purchase price, right? It's not like a normal contract where if I'm going to agree to come and mow your lawn, or if you, enter into a contract. I mean, if you go get a haircut, right? You're agreeing on a particular price for these services to be paid. We don't have any form of an agreement, so we don't have a purchase price. So what we look at here in terms of our remedy and the way that the court provides a remedy in these cases is by following, there's kind of a remedy that's called quantum meruit. So this is another fun Latin legal phrase that kind of straight English definition is it's something along the lines of to the amount that each deserves, or the amount that is earned. It's kind of like that idea. And so what the court does basically is just look at what was the reasonable value of the service that was provided. And that is usually just by looking, like that's like a fair market value type of an analysis, and you can do that in a fairly straightforward type of a way. Now, as far as just to give you kind of an idea of how rare these cases really are, the most kind of easy, straightforward example of this that you see cited quite a bit, like if you look up any legal textbook or anything on what's this quasi-contract thing, the example that people always want to give you is a situation where let's say that we'll use somebody random that we don't know. We'll say that Dave, okay? Dave has a heart attack. He is completely unconscious. He falls to the ground, and somebody around him calls 911. The paramedics show up. They are treating Dave at the scene. They take him to the hospital in the ambulance. He's at the hospital for some time. And meanwhile, this entire time, he's unconscious. Well, eventually, right, let's say that Dave recovers. He's doing well in the hospital. He receives treatment. He goes home. Everything is great. Well, after that, right, Dave is going to get a bill for the EMS services, for the transportation in the ambulance, and for the portion of his hospital stay where he was completely unconscious. Now, in terms of the obligation to pay there, right, when we're looking at this based on principles of contract law, we cannot say certainly that there's a valid contract between Dave or whoever and the hospital agreeing to, where we have offer and acceptance, and I will agree to accept your life-saving medical help in exchange for, paying whatever the hospital bill is. So we cannot, even in a case like that, we can't rely on basic principles of contract law to come up with any legal obligation to pay. In the absence of any kind of statutes, and obviously I'm sure there are a million statutes that exist that provide that payment is required or whatever, but you got to recognize that those statutes exist for a reason, and back at a certain point they did not. So the courts have been confronted with cases many years ago, in terms of what do we do here, right? When life-saving treatment has been provided to someone, we can't rely on contract law. What is the remedy here? if you are the hospital, if you are the ambulance drivers, if you are the paramedics, right, how are you going to get paid for this type of service? Um, you know, where's the obligation, to be able to enforce the payment of that bill? And that's where these quasi-contract principles can come in. Coming down to our unjust enrichment point here, the whole idea and the reason the ambulance example, it's a little extreme, but it's a good example, is that, we can say pretty confidently that nobody in their right mind would, you know, would say, hey, if I'm in the middle of having a heart attack and I'm totally unconscious, like I don't want the ambulance to come, I don't want the life-saving medical treatment, right? Nobody would turn that down, right? Anybody would want to obtain that treatment. And we can say, I think fairly reasonably and objectively, that receiving life-saving medical treatment is a huge benefit to any individual. Um, in addition to that, right, we also can recognize that the hospital and all the employees of the hospital and the ambulance drivers, all of them performed an extremely valuable, socially beneficial service, and we want them to be paid for the work that they're doing. So because of that, it's a good example of unjust enrichment. We can say here that if the obligation to pay the bill is not enforced, Dave is going to be unjustly enriched at the expense of the hospital and all of the people who work at the hospital. So in that case, if there was a refusal to pay the bill, the hospital would be able to base its claim based on this quasi-contract principle. And the remedy here, because there is no agreed upon price, would likely be, if we calculate it as the reasonable value of the service. There's probably, the hospital is probably going to be able to point to numerous cases in the past where it's charged a particular rate for each of the services that it had provided. In other types of similar cases, you could look at kind of hospitals in the surrounding area or within like the state or in similar markets. I mean, there's 1,000 ways that you could do that, but you'd essentially be kind of looking at like what's the fair market value, what's the going rate for these particular services, and that's what would be charged in those types of cases. One other just kind of quick example that kind of popped up in my own life at one point. I remember not too long after my husband and I had moved to Troy, and actually I think we were like, I think it was like literally days after we had moved into our house here because I'm pretty sure I was in the process of unpacking. At one point, my husband had said, hey, I'm going to go to Lowe's. I need to pick up a few things, and then I'm going to come back and mow the lawn. And I said, okay, that sounds fine. Well, like 5 minutes later, I hear a lawnmower going. And I thought, okay, he must have just decided to mow the lawn first and then go to Lowe's after. So I didn't think anything of it. Well, next thing I know, I go and look out the window and I'm like, half of our lawn is mowed and that's not my husband out there mowing the lawn. There was a guy in like a big riding lawnmower. And so I text John, I'm like, do you know anything about this? And he's going, no. But at that point, he was basically home. And he's like pulling into the driveway. And so we both go out there and, flag the guy down and say, hey, hi, like, why are you here mowing our lawn? Like, we just moved in. Well, as it turned out, here he was, and he had somehow like been given the wrong address by his company, or he like mixed up the houses or whatever, and he just mowed the wrong lawn. But I always kind of think about that example. Now, in the example that I gave, now we offered to pay him. He said, no, don't worry about it, but hey, give me a call in the future. So that was kind of a nice, like, kind of a nice advertising sort of a technique, right? Do us a favor and then, hopefully we'll call him back. So we did offer to pay. I think even if we had not, I'm not sure 100%. I think that one would have been a kind of iffy case as far as whether he would have been able to raise an unjust enrichment claim, right? I'm thinking in terms of things like he's the one who made a mistake. And like, yes, we did benefit from having the lawn mowed, but, I didn't, it's not like I looked out the window and saw him doing it and thought, yeah, like we're getting our lawn mowed for free, right? The instant we recognized what was going on, we ran out and stopped him and said, hey, just to clear up any confusion, kind of what's going on. However, right, if we change that example just a little bit, imagine a situation where, I did, right, at some point, maybe like a minute in, right, he's only been mowing the lawn for a minute. I look out the window and see what's going on, right? I know that we didn't hire this guy. I know it has to be a mistake. And I just let him go, right? I just let him finish the whole thing. At that point, right, now it does seem like it's a little bit more unfair, right? Like I had the opportunity to stop him from doing all that work, right, to clarify the confusion. And basically I was like, in this kind of turned around example, I'm sitting there sort of banking on, or I'm taking advantage of the fact that I know he's made a mistake. And that is starting to me to get into some unjust enrichment type of territory, even though, it was kind of his mistake in the first place. So that's, but all of those things, right? This example is kind of a good one because it's very consistent with how we analyze any kind of an issue in when we're dealing with like an equitable doctrine and equitable remedies, right? It's really looking at the whole big picture situation, right? We're not getting super nitpicky about elements and what do we have. We're saying, hey, look, we've got this basic principle of unjust enrichment. We know that we don't like that. It's not something that we want to promote. And then you're looking at all of the surrounding facts. You're looking at what the parties knew. You're looking at who may be at fault and how much they were at fault. You're kind of weighing, the interests involved. And that really is consistent with how equitable remedies work. So that kind of wraps us up for quasi contract. Again, a very limited, narrow exception to basic contract principles, but it is something that's important to be aware of, both in terms of whether you may end up on a plaintiff side at some point or on a defendant's side at some point. But that will take us through today's video. And this is getting to be an awkward conclusion, which I just made more awkward by saying that it's awkward. But goodbye.